Trump and his defense demand a mistrial in the New York City civil fraud trial brought by Leticia James. We're going to go through the motion. It's 30 pages long, filed by Trump's defense, and so it should be good. We're also asking ourselves, where's Alina? Where's she been? Story says she's been missing from trial. We're going to see if we have any idea where she might be or what she's up to. And then we'll take a look, another day of trial. This one is with the finishing of the direct exam of Jason Flemings, an accountant who does some forensic accounting, and the brief cross-examination in trial that occurred. So we'll start off with how things unfolded in the morning with a new motion for a mistrial. We've been waiting for this one. We've been following Judge Engoron and Leticia and all the shenanigans out of this courtroom for quite some time. And we've been waiting for this one, right? And the media has been asking about this too. They've been wondering, asking Alina and the rest of the defense, when is this coming? Are you going to, ask for some sort of a mistrial? And they say, yeah, hang on. Here it is. And so here's what it says. Filed in the case of New York brought by Leticia against Trump, Weisselberg, Trump Jr., everybody, blah, blah, blah. This is Trump's memo of law in support of a motion for mistrial. The Constitution guarantees defendants a fair and impartial trial. Here, in an unprecedented case commanding worldwide interest and attention, it is imperative that nothing compromise that guarantee and thereby undermine public confidence in our legal system. And backing up briefly, this motion is filed in the same court of Engoron, just to be clear. So it's Engoron who is getting this motion, right? So Engoron is the guy who's been presiding over this botched clown show of a trial, and they're submitting this to him saying, hey, judge, you're doing a pretty terrible job. Now, while counsel, Trump's defense, are subject to a gag order from Engoron, apparently imposed to impede the issues herein presented from becoming public. You don't want us talking about this. Alina's been trying to hit the media, and they say, can you tell us what's happening with the love notes between Greenfield and the judge? He's like, I can't talk about it. The judge gagged me. He doesn't want me talking about his GF. So they say it is a fundamental precept of American jurisprudence that sunlight is the best disinfectant, which is why we have a spotlight here for when they try to cower in the dark of night. Indeed, the assumption that respect for the judiciary can be won by shielding judges from published criticism wrongly appraises the character of the American public opinion, and an enforced silence, however limited, solely in the name of preserving the dignity of the bench would probably engender resentment. Yeah, it does. Suspicion and contempt, much more than it would enhance respect. Supreme Court said that in 1941. Pretty smart line there. Yeah, the judge is saying, you're gagged because you can't talk about my Greenfield, my GF, in my courtroom, and you can't criticize how we're handling this, and gag, 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 right? They say that gag is harmful to their case. It's going to jeopardize and undermine the legitimacy of the institution. But when they gag you, every one of us turns around and just says, oh, that's perfect, right? Typical. It's exactly what tyrants do. And we take it and amplify it and magnify it, right? This is also something called the Streisand effect. When you try on the internet to silence something, everybody goes, oh, that's curious. Why are you trying to hide that from us? We don't like you hiding things from us, so how about we re-X that into oblivion? And that's what ends up happening. So the same thing here, except now this involves politics, and of course the gag is partisan and corrupt. And so we now have questions about why they're trying to interfere with an election in addition to prosecuting, and in this case, stripping one of their political opponents of $250 million and wrecking his businesses. So while the court has restricted public criticism of itself on the issues herein presented in a series of unconstitutional gag orders, and I know we're a lot of gagging going on in the Trump cases, but this is New York City, not Chutkan, which is currently on appeal. But to be clear, Chutkan's gag order and this gag order, they feed off one another, right? They say, see, Trump's doing it in that court, so we got to do it here. And then they, vice versa, they flip it around. In this case, these gag orders were entered sua sponte, which means on the initiative of the court. They just decided to do it on their own. The Supreme Court instructs our Supreme Court that the operations of the courts and the judicial conducts of judges are matters of utmost public concerns. So if you are sending love notes to your GF in court, Judge Engoron, we should be able to talk about that, as should the judges. Now they say, moreover, Judge Engoron, there can be no doubt of the public perception of bias in this case. Even commentators who are politically opposed to President Trump have noted the biased nature of these proceedings and the astonishing departures from the ordinary standards of impartiality. See, for example, Andrew McCarthy. He wrote about it at the National Review. He said, the case against the former president lacks victims, and he calls her Tish too. My man. So he says, so Tish James, because that's her Twitter handle, man. It's not just me. That's what she went by. So Tish James and Arthur Engoron. Now, at some point, I think McCarthy will join us and he'll insert the Areola moniker here, his middle name, Areola. So Arthur Ari Engoron is how we'll call him here, are inventing some. Engoron, Areola, keeps cutting Trump and his lawyers off by insisting that he has already decided Trump, A, committed fraud, right, just decided it, and B, overvalued his assets, just made that decision, and C, cannot be be insulated by the disclaimer that is in the documents, and advising his counterparties that disclaimer was, hey, what I'm showing you, it's not accurate. Like, it's my interpretation, but you should do your own due diligence. Judge says, well, that's still fraudulent. But no, you said, but I disclaimed any fraudulent intent. If I was committing fraud, I wouldn't have put the disclaimer in there saying you should do your own due diligence. I would just say this is accurate and just do it, right? The judge, well, now that really wrecks my case. I have to find you fraud, obviously. So the appearance of bias, as they say, threatens both Trump's rights and the integrity of the judiciary as an institution. I mean, to try to communicate the damage that they have done to the DOJ and to the concept of the law with these multiple different prosecutions, I think is probably irreparable, to be honest with you. And it's a sad thing to say and to admit. Like, the 4 different criminal prosecutions, plus what they've been able to do in New York with the civil prosecutions with E. Jean Carroll, Miss Bergdorf, and then the other civil fraud case that we're talking about here, it is wrecking, I think, the public's perception of the judiciary. Then you add in January 6th, then you add in the FBI and all of the weaponized, domestic incursions that they're investigating, plus all the censorship. I mean, it is them doing the damage. It's not Trump and his Truth Social account, all right? So they and their gag orders, again, multiply and amplify all the criticisms. So as developed herein, Trump's defense says, in this case, the evidence of apparent and actual bias is intangible and it's overwhelming. Such evidence, coupled with an unprecedented departure from standard judicial procedure, has tainted these proceedings and a mistrial is warranted. We got the GF coming up. Specifically, they say the court's own conduct, Judge Engoron, coupled with the principal law clerk, the GF, Allison Greenfield, which is why we call her the judge's GF, her unprecedented role in the trial and the extensive public partisan activities would cause even a casual observer to question the court's partiality. Thus, only a grant of mistrial can salvage what is left of the rule of law. Yeah, maybe. I'm not sure. It's pretty much damaged. Now, they say on argument on defendant's motion for a directed verdict, they give us an example that they referenced in footnote 1. They're saying, hey, judge, you got some pretty serious bias here, footnote 1. Specifically, we were asking for a directed verdict, which means, in other words, the government presented all their evidence, and even if you believed all their evidence and took it all as true, there's still not enough there to convict or to find Trump liable for the fraud and the disgorgement. So they made the motion for a directed verdict. Judge, we can't lose, okay? They presented no evidence. Specifically, they were making the argument about what weight should be accorded to Trump's testimony. And the court asked the following question. The court said, Engoron says, can I bring up something not in the record, but a matter of public knowledge? Says Engoron, I guess. I think the perfect call with Zelensky about the military aid, there might have been code rather than straightforward talk. What? The court asked the following question. Can I bring up something that's not in the record, but a matter of public knowledge, the judge says? I think the perfect call with Zelensky that Trump always rails about on, Fox News, about military aid, there might have been code rather than straightforward talk. People are going, what the heck are you talking about, man? He's already impeached over all this crap. We're here in trial with Tish for business deals. So this is an affirmation of Clifford Robert. So they probably got somebody who is signing off that I heard this stuff. They say, Your Honor, such reference to a purely political trope demonstrates the court cannot separate his, Engoron's, and his principal law clerk, his GF, their political bias from the obligation to be fair and impartial. They say, Your Honor, this court has contravened the code of judicial conduct, and you've created the appearance of impropriety through publicly commenting on a proceeding before you. This court, in its capacity, Your Honor, as the Wheatley School alumnus, which we read through the letters here, that was the Areola show, which was a wild scene here, but we had to analyze a judge's nipples on this channel because he put it in his newsletter, not because I wanted to. It's part of the court record here. This court, in his capacity, this judge, as his Wheatley School alumnus, has publicly posted links in the newsletter that he maintains to articles disparaging the parties in the council. We saw that. That was in addition to the bonus torso photo that he also weirdly exhibited, not voyeured, he exhibited. We learned about our degenerate terms last show. Exhibited in his newsletter, but in addition to the bonus torso photos and his areolas, we also saw him put links in there. He was, he's like proud of his work. The judge did this. The judge denied Trump. The judge did this. He says here he was bashing Eric Trump, President Trump, Miss Abba, Cushman, and Wakefield, and covering his own decisions in derogation of the code. The code says a judge shall not make any public comment about a pending or impending proceeding in any court within the United States or its territories. The judge is shoving it in his newsletters next to his nipple photos. Here, look at this. Ah! Like, no. In an October 2nd, 2020 newsletter, which we covered here, and that's a wild show. You should go check that one out for sure. This court included links to articles about Eric Trump being compelled to testify in a subsection called Art Engoron Articles About Decisions, right? And we covered that here. In December 28th, another newsletter newsletter, the court also linked articles to the judge's decision about the Trump Organization. He linked to Bloomberg, WAPO, CNN. In February, this court also included links to articles that he characterized as a humorous, irreverent take. He's just, no, I'm just having fun with this. In November 2021, the newsletter, the court entitled 1967 Man in the News, that's Judge Engoron, he's talking about himself, look how great I am. He linked 5 articles, again, from Washington Post, from CNN, and from Bloomberg about his order in the special proceeding that compelled Trump to turn over the documents. It's like his Facebook account, right? He's like, look what I'm doing. I'm ordering, I'm compelling Trump to do this. Look at my chest. In March 14th newsletter, 2022, so we just keep coming closer, the court likewise in the graduate news section posted links to the New York Times, Washington Post, and Politico regarding his decision in the special proceeding to order the defendant to testify. I'm going to order Trump. Look what I'm doing. May did the same thing. Posted in New York Times, he's holding Trump in contempt. Man in the News. The court again linked to an NPR article saying that Trump lost his appeal. This is Engoron, right? This is the judge. The court is a nice, euphemism for this guy. It is Engoron who is thrilled about this. He's doing cartwheels with Tish. Yeah, anyways. The court similarly linked an article from Business Insider and 2 days later then held Cushman and Wakefield in contempt. And finally, on September 11th, just 10 days before this lawsuit was filed, the court posted a link to the Above the Law article criticizing Miss Abba in September 11, 2022. So this judge is now presiding. So they say, obviously, this judge is biased as can be. He's been spamming his anti-Trump lawfare, his little attacks to his captive audience from Wheatley. Now, the court, they say, also has improper judging, and this is where we're going to see from the Greenfield. They say, Your Honor, Engoron, you have impermissibly exceeded your discretion. He says, it's just my law clerk. We have a very, I forget what language he used, a very curious, commingled relationship, and that's normal. And we're like, well, I don't know what that means there for you guys. But they say you've exceeded your discretion in granting his principal law clerk, quote, unprecedented status and input into these proceedings and restricted the speech of anyone who even seeks to comment on this status. They were saying, hey, she's passing love notes, and that's inappropriate. And they say, don't you talk about my love notes. She wants to massage my neck. She can massage my neck, and I don't want you talking about it. Now, input or any perceived partisan bias, not allowed to talk about it. This court has, during the special proceeding, all pretrial proceedings, and since this trial began, allowed his principal law clerk to preside on the bench with him to his right-hand side, literally sitting up there next to him. It is a co-judge, okay, not at a clerk level. This arrangement is depicted below in the photographs published by Getty Images and the Associated Press. They're literally like at the same level with laptops. She might be playing footsie with him. You can't tell. Look how close they are. I was only joking about the love notes, but it might be, you could do a little old, hand on the knee maneuver or something like that. And I don't want to get carried away with this, but they're awfully close. Now, you never see this in actual practice. Like they have their laptops together. This is the court actual the court computer that's built there. She's got her laptop here with all the notes and she's within touching distance of this judge. Wild. And they're just communicating. They are co-presiding over this case. And that is very, very strange. Okay, so they're calling that out pretty aggressively here. And they say, here's another photo. There they are. The judge and his Greenfield. Oh man, she does not look happy, probably looking at Trump right there. We're going to learn more about her, no doubt about it. But is this what you normally see when you watch different court proceedings? Do you see the judge? Let me ask you this. Is this a court of appeals, for example? Like think about that. The Supreme Court, do they all sit on the level, right? They all sit on the level. This is by design, by the way. Like the judge is above everybody else for a reason, right? They don't put the judge below everybody else. That's why the judge is up there. And the clerks are down. The witness is down. Everybody else is down. And the public is behind the bar. So all of this is by design, right? This is elevating this judge. She's not a court of appeals, a co-judge, another judge on the bench. No, not at all. How do we know that she is not acting as the judge? That's the point. This is Arthur Engoron. This is Allison Greenfield, sits alongside him right up there on the bench. Now they say, as these photographs reflect Engoron, weirdo, the principal law clerk is given unprecedented and inappropriate latitude. Before the court, they say, rules on most issues, the court either pauses to consult with her on the bench or receives from her contemporaneous written notes. Now, while a justice of the court, no doubt, has ample discretion to consult with his or her law secretaries, this unprecedented arrangement exceeds the outer limits of this discretion. They say, Judge, at a minimum, the appearance of, quote, co-judging is manifest, and the public and litigants may conclude fairly that an unelected staff member has, as is evident from the above images, a literal direct role in presiding over the trial. This creates the appearance of impropriety contrary to the letter and the spirit of the rules of the judicial canons, saying, quote, "A judge shall avoid impropriety and the appearance of impropriety in all of the judge's activities, which would include love notes with your Greenfield. Only a judge, not an unelected staff member, may exercise judicial authority under the New York Constitution, or unauthorized practice of judging," right? And the people of New York declined to elect the principal law clerk when she ran for office. Oh, she's a wannabe judge. Oh my gosh, it all comes into play. She ran for office, and now she's just playing judge. Oh, isn't that fun? Now you know the personality. Now you know this person. Great. Well, I'm his principal law clerk, though. Well, yeah, but you're not a judge. But I'm his principal law clerk. Okay, Allison, relax. So she, therefore, has no constitutional authority to act as a co-judge, and the impropriety of her participation is further magnified by the fact that she has violated a separate canon of ethics by making partisan political contribution in excess of strict limits, including to organizations actively supporting Attorney General James and opposing President Trump. And you can tell that just by her face. Look at this face. Okay, look at that. Like, you can just see she hates Trump and loves Tish. Gosh. And so, of course she did. She made all those donations, ran for office as a law clerk. Good thing she didn't get elected, because apparently she doesn't understand the ethical rules that you're not supposed to do that stuff. Regardless, the Trump defense says the impact of this untoward level of participation by the principal law clerk, Engoron's GF, cannot be overstated. Indeed, during a candidate forum in connection with her erstwhile campaign for the Manhattan Civil Court, where she lost, the principal law clerk herself framed her role as a co-equal, describing her participation in a high-profile real estate as follows. She says, "We were incredibly active in that case, and we tried to stop the two towers." And during that same forum, she described her judicial philosophy as driven not by the facts and the law, but by political considerations. She says, you know, one thing that I think is incredibly important to consider is, what would the people who elected me want me to do? You hear that? Gosh, she didn't get to become a judge, but now she's role-playing one. And is there any precedent that would allow me to achieve that outcome? Okay, so she's an activist. That doesn't follow the law. How can I manipulate to get the outcome that I want? So this statement is fully contrary to the rules of judicial conduct, which says that a judge must be faithful to the law, derp, and must not be persuaded by partisan interests. Saying a judge shall be faithful to the law, this is part of the code for judges, and maintain professional competence in it. A judge shall not be swayed by partisan interests, public clamor, or fear of criticism. But of course, that's what all these people are doing. Now, we talk about the gag orders. They say, also, as part of her campaign, the judge's GF, the principal law clerk, created and maintained a website. It was called Greenfield for Civil Court. She started a website and an Instagram and a Twitter account. And in February 2022, while the special proceeding against many of the same defendants in this case was ongoing, she posted on her Greenfield for Civil Court Instagram endorsements from the Village Independent Democrats and the Grandstand Democrats. On February 26, she made a post purporting to withdraw from the Democratic primary, but advised followers to keep an eye on this space. Now, thereafter, she continued to post on the Greenfield account. For example, on April 30th, she posted a picture with Senator Chuck Schumer, which was ultimately reposted by the Judicial Protest Twitter account and subsequently posted by President Trump. In the photo that she took with Chuck Schumer, which is why Trump, I think, said she was Chuck Schumer's girlfriend or something like that, she's captioned, she put the photo online. She said, "So thrilled to attend the Chelsea Reform Democratic Club Founders Brunch today, honoring incredible and fearless lifelong public servants like Senator Schumer and Rep. Maloney. Thank you, CRDC NYC, for a fantastic event." They say, Your Honor, it looks like the Greenfield for Civil Court account is still active, but was made private in the days leading up to the trial. Now, I just want to pause on this. This is Judge Engoron, okay? And he must be reading this just exploding, okay? I can't even imagine how mad he is, because he was screaming at them in court. Don't do it, Chris! Don't do it! When Chris was saying, I'm going to file a response, he, don't do it! And now he's airing out Greenfield's Instagram account, and she's like dancing around with Chuck Schumer. He's like, wait, hey, Allison, I thought that what? Schumer? Chuck Schumer? I know Chuck. Really? I had no idea. I thought we were going to be forever. But, you know, so he's having a meltdown. Not only is Christopher Keese airing out all this dirty laundry of this relationship, but now Judge Areola is having to deal with Senator Schumer, who's a senator. You know, he's kind of a little more powerful than this judge. Man, hearts are breaking there. So following a repost of the Schumer picture by Trump in what may reasonably be interpreted as an effort to shield the law clerk's, quote, co-judging and her partisan political activity from public scrutiny. The court, sua sponte, on their own, entered an unconstitutional gag order prohibiting all parties from posting, emailing, or speaking publicly about any members of his staff, including his Greenfield. Now, she posted it on her account. This was all public. This was on her civil court Greenfield 4 account. And Trump just retweeted it. So it's not anything private, okay? She was, probably got a lot more views. So nonetheless, the principal law clerk, the GF, her unprecedented role in the proceedings after the unconstitutional gag continued to be the subject of significant on-the-record colloquy, right? They were battling over the stuff in court. Your Honor, a lot of conversation about it. For example, on October 25th, 2023, Mr. Keese, the defense lawyer for Trump, he described the, quote, considerable tension caused by her position on the bench. Your Honor, you're making us very uncomfortable. Can she not reach over there under the desk? Please, man. Saying it's considerable tension is being caused by her position on the bench and indicated that it is, quote, unusual for a principal law clerk, GF, to sit on the bench. Now, Mr. Robert described his experience. This is Robert who wrote this affidavit or this affirmation. He says, Mr. Robert described his experience in New York State, such as he had never seen a situation where you're literally trying the case to two judges with notes constantly being passed. Okay, so this guy that they're submitting as evidence, like, Your Honor, it's not just the lawyer saying it. Okay, we've got evidence on the record. This guy wrote a whole document about it. You're literally trying the case to two judges and notes are constantly being passed, among other things. So where it would, quote, appear the court is in consultation with the principal law clerk with each ruling. She's just, the wannabe judge is like actually getting to role play judge. She's LARPing right now. So Mr. Robert, he further described that this court would, quote, appear to be leaning in one direction, and then he's going to receive a note, or there'll be an eye gesture or a roll of the face, and something changes, and it is significant concern to the defense. The judge is like, yeah, that's a good point. What do you think, honey? Overruled. Yeah, that's what I meant to say. Overruled. See you tonight. So Miss Abba says, Your Honor, it is incredibly distracting when there are eye rolls and constant whispering at the bench when I'm trying to cross-examine a witness. Can you two get a room later? I'm in the middle of an exam. The following day, counsel added, they said, Your Honor, I think that Trump has a legitimate basis to raise these arguments because he is seeing, as he's told me on a regular basis, head nods. Trump can see it. Eye rolls. He's seeing notes being passed. He's seeing head shaking, comments on arguments that I'm making. Trump is saying it. I have to bring it up. And so they say when we brought this up, the court notably had no rejoinder to that statement. Like, what do you want me to do about this, Judge? My client is sitting here and he could see it. Now, the following week, the defense requested further clarification. They said, look, Judge, we need to continue to make a record. We're going to make a record every time that you accept a note from your Greenfield or other conduct that we think evinces bias. We're going to make a note of it. We also think that there are news reports that have come up that show there are violations of ethical rules by this court and your law clerk. Like, the news knows it too. And the lawyers also noted that since comments were made on the record about the constant note passing, the closed circuit camera angle had been changed. Oh my gosh. These people are just as devious as it gets. They will tell you that they want this all to be public, won't they? But first of all, it's not, okay? Now, there's a closed circuit camera that people can watch in the courtroom, right, where the people in the media can be commenting about this stuff, but they hid it from them too. They've gagged people in the courtroom and they're changing the camera angles so you can't see the love notes or whatever, okay? Whatever they're doing there, which I don't know. They're on the same level. There's a big bench there, right? You can't see. The bench is up there. You don't know. Wow. So they say counsel also noted that since we commented on this, the closed circuit camera angle had been changed, which made it more difficult for the public to see any note passing. The court admitted to knowing the camera angle had been changed, but feigned ignorance as the reason. Your Honor, why was the camera moved? Now, as for the camera being moved, this person said, I was vaguely aware that Rob, the tech person, was switching the angle of the camera. Never occurred to me that it could have anything to do with what we're discussing today or why it was. That's what Engoron says. No, I don't know. Bad angle, bad lighting. That's why we changed it. These people. Now, as further colloquies, further conversation in the court, this court concluded, Judge Engoron, that he would, quote, consult with his principal law clerk for the trial. In fact, every week or every day, and to consider the record preserved and closed, as the court has, quote, an unfettered, absolute right to consult with my law clerk anytime, any place about any matter, even love notes and foot massages. Now, ultimately, the court issued a second gag order, prohibited even the lawyers, okay, so not just Trump, but even the lawyers, from making any public statements in or out of court that refer to any confidential communications in any form between me and my staff. That's the judge, right? Like pounding the table, freaking out, which is why I'm saying that as this is all being publicly read and as we're reading it right here, and as I hope you share this, that more and more people know about all of this stuff, because the judge, oh my gosh, he must be losing his mind right now. He said, don't do it, Chris. They did it. Now, the following day, lawyers came back. We sought clarification asking. They said, Your Honor, we want to move for a mistrial, and we have a question. Are you going to hold us in violation of your gag order? And the court said to Chris, he says, I'm going to file a motion for a mistrial, and I'm going to challenge your gag order and all your weird love notes with your Greenfield. I'm looking at you too, Allison. You're coming up in this note too. We're going to look at your Instagram at 2. And the court responded using counsel's given name rather than his surname, right? He's calling him Mr. Keese this whole time. The judge screamed at him, don't file that motion, Chris. Don't file that motion, Chris. And man, when my mom used to call me Robert from across the house, oh man, it was big trouble. Robert! Oh gosh, she found the thing. Yeah, oh gosh. So this is pretty serious, you know, in a household with a mother scolding her son. Like, okay, that's fine. But this is a court. This judge is not supposed to be biased like this. And he's getting very reactionary here. Then, after yet another, quote, confidential communication, she passes another love note. She's like, hey, don't call him Chris. You're kind of losing your cool here. Relax. The court then allowed the defendants to make a motion. She's like, actually, you have to let them do something. You know, she's like, not an idiot. They got to do something. Otherwise, this thing's going to blow up. So she says, okay, the court says, okay, you can make a motion, which is the one we're reading now, without violating the gag order, but said that any motion would have to be in writing, which is perfect. It's the one we're reading today. Trump's defense says, now imposing limits on a party or a lawyer's ability to address in court the issues in court is simply not justifiable. And it's certainly not consistent with the avoidance of the appearance of impartiality. It's in fact the opposite. They say the right to a fair trial is sacrosanct. Thus, anything that at all infringes, potentially or otherwise, on such a right must and should be questioned in open and in a public forum. And we're doing that now. They say the principal's law clerks, the GF's partisan activities, all those donos and such, those are directly imputed to the court. That's you saying the appearance of impropriety created by Greenfield and her co-judging and this court's repeated attempts to silence us is further exacerbated. So if that's not enough, if not, you know, the love notes and the massages and all the things, plus the gags, several of those, we can add in her partisanship under the law. First, this court and her violated this court and the code of the judicial code by allowing Greenfield to contribute to Democrat causes in excess of the permitted amounts and to engage in impermissible partisan activity. The law says you can't do it. In fact, it says a judge shall prohibit Engoron, members of the judge's staff, which would include a principal law clerk, even if she is your GF, from contributing directly or indirectly money or other valuable consideration in amounts exceeding $500 in the aggregate during any calendar year. That comes from the New York Code, section 105C2. Now, as set forth below, during the pendency of the special proceeding that led up to this case, and then after this case was already filed, the judge's Greenfield contributed over $3,000 to Democrat candidates and organizations in 2022, and over $900 this year alone, which is a lot of money, right? I don't know what everybody else's political spending is, but that's a lot. You know, it's like times are tight right now. You got extra $3,000 to just drop at Democrats? Like, you must be pretty serious. You know, I think most people will donate 20 bucks, 50 bucks, 100 bucks here, and I really support this guy, 100 bucks maybe, but like she's maxing out. That's a lot of money. So she's pretty, you know, into it, I would say. The official New York State website publicly chronicles these contributions. Well, let's take a look at them, shall we? Oh, it's a lot of them. Oh, the judge does not like that. Oh, it keeps going. Oh man. So the judge didn't want any of these love notes to be known, and they got 4 pages of her donos. Here's what they look like. Who is she giving this money to? All right. So on May 2nd, the judge's GF made contributions to the Four Freedoms Democrat Club, Chelsea Reform Democrat Club on, well, the month prior to that. 175, 350, 50 bucks here, 50 bucks here, 210 bucks here to the Chelsea Reform Democratic Club. Democrat Downtown Independent Democrats, 250, another 250, $500 here to the Jim Owls Liberal Democrat Club. Here's some more Democrat donos from the judge's GF. 250 bucks to another Jim Owls. Sylvan for New York got 100. More Democrat committees. The New York Democrat Committee, like that is the hard Democrats. Like that's hard party stuff. Okay, 25 bucks, 50 bucks to them. She's loosening up her spending a little bit. CODA district leaders, Friends of Kim. Oh, we got Friends Friends of Kim, whoever that is. We got Harvey for New York, Jim Oles. We got 4 Democrat freedoms. Now, here you go. More troubling than even the fact that these contributions exceed the lawful limits, many, if not all of these organizations actively support the Attorney General, Tishy Letish. For example, the president of the Grand Street Democrats published an op-ed in 2020 proclaiming Leticia James is the last line of defense against the Trump administration, which is crazy. And she donated to the Grand Street Democrats, right? They're all over the place on these lists. Grand Street Democrats. Let's see, we saw those at the beginning. And Chelsea Reform Democratic Club and New York for Alex. Here, there it is. Grand Street Democrats. Wanted to make sure I found it actually in the document. So Grand Street Democrats specifically showed up and spoke, and they said that Letish, who's prosecuting this case, is the last line of defense against Trump. So also Greenfield contributed to Grand Street Democrats, which endorsed Tishy in 2022. Here's what they said. They said, while progressive AGs like Tish James, okay, that's her account, while they have worked tirelessly to fight back against Trump's agenda, Republican AGs actively work to support and raise money from his lies and lawlessness. And so they're where she's sending her money so that they can keep speaking out against Trump. Now, moreover, they say while this case was pending, Allison Greenfield attended a Grand Street Democrat event where speakers openly advocated for Joe Biden. She's politically active, shows up at a rally. Speakers also commented to significant applause there, saying that on the fight against the developments and profits of big real estate and fighting, saying that there should be consequences for former President Trump, showing up and they're railing against real estate and Trump specifically. Now, all these contributions and these partisan activities, they violate the judicial code, Engoron, and they're attributable to you, this court. And indeed, even as a candidate for judicial office, Ms. Greenfield was bound by the code, and it precludes a candidate from public election to judicial office from engaging in partisan political activity. It prohibits you from publicly endorsing or from even attending political gatherings. So she should have known. Now, at base, a judge or a non-judge who's a candidate shall maintain the dignity of the appropriate judicial office. But here, Judge Engoron, the principal law clerk, your GF, who sits on the bench next to the presiding judge, sitting there, co-judging and consulting with him on a real-time basis about nearly every ruling, has engaged in literally prohibited partisan political activity with respect to the parties before the court while their case is pending before the court. It's about as partisan and corrupt as you can be. She's sitting there next to you, and while this case was going, she was actively involved making donos and showing up at campaign events, speaking about the parties in this case. And she's sitting there co-judging the case with you, Engoron. So he must really be in love with this woman or something. Now, the court's demonstrable bias is something you can extract from there. They say the foregoing partisan conduct from both this court and his law clerk has resulted in biased rulings throughout these proceedings. First, the court refused to transfer this complex case to the commercial division where it unquestionably belongs. And shortly thereafter, on November 22nd, before the Attorney General even opposed Trump's motion to dismiss, or any discovery had even been exchanged, this court determined the trial would begin on October 2nd, the very date that Tish suggested in her preliminary order. The court ignored both the presumptive 15-month standard in complex commercial cases, just said, no, we got to get this done before the election, hello, and also dismissed the burden imposed on the defense to review millions of pages of documentary evidence and evaluate dozens of witnesses. Now, this compressed schedule also provided a massive advantage to the Attorney General, who had already been working on this case for 3 years in preparations for the filing to take it to trial. And thereafter, despite a letter request and a motion by the defense, the court refused to postpone the trial, stating it did not see a need for extensive disclosure. You don't even need to know what is in their evidence because we're living in a kangaroo time. Now, on January 6, 2023, Engoron denied Trump's motion to dismiss in their entirety. On June 27th, the First Department on appeal of this court's decision modified the underlying decision and order and dismissed the Court of Appeals certain claims as time barred, right? The statute of limitations said that Tishy was bringing these in and allegations were too old. On September 5th, with an impending trial date and no action by this court to comply with the First Department mandate, Trump moved for a brief stay of the trial until we could rule on our motions. We submitted a 15-page memo, but less than 24 hours later, this court uploaded an unsigned order to show cause with the notation, declined to sign because defendants' arguments are completely without merit. So they said, okay. So we were then forced to commence an Article 78 proceeding to compel this court to comply with the First Department's directives. This court finally came out September 26 and issued a decision on the summary judgment 5 days before trial was scheduled to begin. That 35-page decision decision from Engoron denied Trump's motion in its entirety and granted Tish's motion for summary judgment. She wins, Trump loses. Now, the court also granted Tish's motion for sanctions against Trump's counsel, and this left Trump in an unprecedented decision of discovering what claims and issues would actually be tried at trial just literally a few days before beginning a months-long trial with dozens of witnesses, right? Everything just got decided at the very last minute, and they had to move forward. Now, the trial began as ordered on October 2nd. On October 3rd, the court, on its own, imposed its first gag order based on Trump's reposting of the principal law clerk's Schumer photograph, right? Trump just posted what she posted. And the judge said to everybody in the case, consider this statement a gag order, forbidding all parties from posting, emailing, or speaking publicly about any members of my staff. Now, any failure to abide by this directive will result in serious sanctions. And they say in contravention of the judicial rules and the First Department, the court subsequently sanctioned Trump for violation of that gag order. On the 20th, sua sponte, again, the court issued another order finding Trump violated the gag order again because the website still had the post up. $5,000 for the first violation. Trump got sanctioned. On October 25th, during Cohen's testimony, the convicted perjurer who's lied multiple times now, Engoron, on his own, raised President Trump's statement to the press made moments before in the hallway outside the courtroom. Judge said, it's just brought to my attention that the AP reported, now I wasn't there, this is the AP, that Mr. Donald Trump just stated the following to the press outside the courtroom. He said, this judge is a very partisan judge, with a person who's very partisan sitting alongside of him, perhaps even more partisan than he is. And the judge said that Trump was talking about his GF there, but Trump said he was talking about Cohen. They say, now it's very easy for the public, for anyone to know who that person is. This court simply assumed President Trump was referring to his GF when Trump testified under oath. He said, I was referring to Mr. Cohen. But the court nonetheless concluded, relying on its own testimony, describing the layout of the bench and the witness box. The court said this. Before that, Trump posted this. He said, this is Schumer's girlfriend, Allison Greenfield, is running this case against me. How disgraceful. This case should be dismissed immediately. So the judge then said, okay, that was in the first point. Now, I thought Trump said something in the AP in the hallway. He says, listen to Trump. The judge says, as a trier of fact, I find that Trump is not credible, that he was referring to my law clerk, the principal law clerk, who is sitting much closer to me, who doesn't have a barrier, that would make things a little bit more difficult for them, whom I believe has been accused by the defendant of being partisan or Democrat or partisan Democrat. I hereby fine you $10,000, which is on the low side, to be paid within 30 days to the Lawyers Fund for Client Protection. That's the judge. She has like 3 pages of donations to Democrats. She is Democrat and partisan. So the court thereafter issued a second gag order and said, guess what? Trump pays his 15 grand and the counsel, the lawyer, are also prohibited from communicating about my GF. Now, finally, Trump's defense continues. This court's evidentiary rulings throughout the trial have been both legally misguided and biased in favor of Tish. For one, this court has overruled, as a matter of course, any objection to the AG's introduction of time-barred evidence under the guise that it bears on potential injunctive relief, despite being clearly rejected by the First Department decision. They unequivocally dismissed as time-barred any claims that came before July 2014. They said there's a tolling agreement that already accrued, but the First Department directed literally this trial to be circumscribed, okay? You cannot try all of those old claims, but nonetheless, Engoron overruled summarily Trump's continued objections to the documents that predate that period, said any testimony is also admitted. So the court has also permitted the introduction of hearsay testimony under inapplicable exceptions and in some cases without identifying which defendant it might be admissible against. It's a total free-for-all. They say additionally, this court denied Trump's motion in limine to preclude expert testimony that was explicitly keyed to filling in the gaps in their case with testimony that she failed to elicit from witnesses. So the court is letting Tish fill in the holes. Now, the Attorney General never elicited any testimony from any bank representative as to what, if anything, the banks would have done differently if approving the subject loans. Instead, the court permitted the Attorney General to backfill the hole in her case with the testimony of an expert. And so they're going to say, Your Honor, this is the standard for a mistrial, okay? All of this is case law, and here all of this is appropriate. They say you have met the standard as detailed by your own public comments in the Wheatley newsletter. They're beyond the pale. The court is indisputably bound by the code, which says you can't comment on pending or impending cases. A judge cannot do it. But regardless of the venue and the fact that the links were often posted without comment, the court's repeated publicizing of its own rulings and even worse, previewing forthcoming rulings gives an appearance of impropriety in contravention of the code. Now, this court has also violated the code by permitting his principal law clerk, his GF, to make political donations in excess of the permitted amount. This conduct is directly imputed to the court under the code, and she has been acting as a de facto co-judge, which also violates the code. There is an unprecedented arrangement that exceeds the discretion of this court and creates the appearance, if not the fact, of a co-judge presiding over this trial. Having the principal law clerk sitting on a bench leads inexorably to the conclusion that she is acting in accordance with her overtly public and partisan views to essentially implement what, quote, the political people who support me want me to do. The notion she somehow provides impartial input is based on her own words and conduct untenable. It creates an appearance of impropriety which violates the code, and court employees are also included under the rules. The law clerk, Greenfield's, extensive partisan activities during the pendency of this case also violate the code. As set forth in detail, public postings with prominent Democrats, contributions to Democrat causes in excess of the rule, including people like the Grand Street Democrats, attending highly partisan political activities, all violate the code and give us concerns about her bias and impartiality, especially as a co-judge. Now, all of this conduct, including supporting political groups that vehemently oppose President Trump, was singularly partisan and thus in violation of the code. And of course, the code says that the courts must be faithful to the law. Judge Engoron, in sum, there is simply no room at the bench for such open and obvious indicia of bias. Indeed, left unchecked, the introduction of such demonstrable pro-attorney general and anti-Trump real estate bias into a case of worldwide interest involving the frontrunner for the presidency of the United States impugns the integrity of the entire system. And so, Judge Engoron, the gag orders and the enforcement thereof reveal the court has christened itself Camera Stellata, judge, jury, and executioner, proceeding sua sponte on their own to act against President Trump in violation of the Constitution, the judiciary, and the First Department rules. This star chamber approach is particularly indefensible when the gag orders actually shield the court itself from public criticism of perceived bias, one of the most fundamental rights of the First Amendment. It's the whole point. The court's efforts to silence the lawyers from objecting and creating a record of what anyone could observe publicly taking place in the courtroom during the trial plainly augments the appearance of impropriety. They changed the camera angles. First, the October 20th sanction was raised by the court on its own in violation of the rules. A court is permitted to summarily punish contempt in the absence of motion only where the offense is committed in the immediate view and presence of the court. And so the continued existence of online posting is indisputably outside the view of this court. So Trump should not have been sanctioned for that first 5,000. Now, setting aside the procedural infirmities, meaning the judge is just doing whatever he wants, punishing Trump, this court has made clear that it would like nothing more than to manufacture reasons to sanction the frontrunner of the 2024 presidential election because it disagrees with him about the existence of bias. And second, Judge, you sanctioned him again in October. You did that on your own after the court learned of the comment to the AP. Now, that remark was also made outside the court's presence, but again, you punished him even though you had no authority under judicial law to do it. And you even listened to him and said that he was not credible. And they said that a judge cannot serve all multiple roles as the indicter, the complainant, the indicter, the prosecutor, and the judge. You can't do all those things. But here, the court has served as the complainant on its own, raising the issue of the statement to the Associated Press. Okay, nobody complained about that. You heard it, Judge, and you brought it up. You also then indicted him under the statement. You brought him up to give testimony. Then you questioned him as the prosecutor, and then you deemed Trump not credible, and you sanctioned him. Now, you conflated the roles. You're a judge. The rules under New York law say you're not supposed to do that. We have principles of due process and fundamental fairness, or used to. They say the court here effectively assumed the advocacy role traditionally reserved for other people, and it did so to silence everybody from preventing public comment about his law clerk. Now, even if Trump had referred to the law clerk, which he did not, the veracity and the propriety of the conclusion that she is partisan has only been bolstered since the statement was made. Having made credibility findings of testimony, the court compelled in violation of the rules, all the while presiding over the bench, the court cannot unring the bell of its own bias. Ooh, that's good. Unring the bell of its own bias. The entire episode establishes fully the court has already determined Trump is incredible based on nothing more than the court's own surmise. To proceed with a bench trial under these circumstances would be the apogee of bias. Now, third, on November 3rd, the court impermissibly extended its gag order and extended it over to counsel. They were only seeking to preserve the record for appeal, but this unconstitutional unconstitutional order. It interferes with the lawyer's ability to even advocate for their clients. Like, talk about ineffective assistance of counsel. Like, the judge said, you can't do your job, by raising objections to the judge's own improprieties, and was entered after, arguably, because of comments by counsel on the record about his principal girlfriend, GF. Now, in the written order, this court again specifically named Trump's principal's attorneys and accused them of making repeated inappropriate remarks about his GF, falsely accusing her of bias and improperly influencing the trial. Now, as the record reflects, the record observations of counsel were both accurate and well-founded. But nonetheless, gag order from Engoron curtails the defendant's rights by precluding his lawyers, Trump's lawyers, from abiding by their ethical obligations to create a thorough record on the appeal. They can't do their jobs, given Greenfield's obvious and demonstrable partisan activities and her, quote, de facto role as the co-judge. The notion of impeding counsel's ability to establish a record creates an unquestionable appearance of bias and impropriety inconsistent with the code and the Constitution, which guarantees a fair trial. Now, wrapping up, they say, as noted above, the court's evidentiary and in limine rulings at trial also demonstrate bias. The reason for these rulings appears plain. The court intends to, in contravention of the First Department's decision, consider, quote, evidence rather than claims that accrued prior to 2014 and grant overbroad and unauthorized injunctive and monetary relief. Now, the court's rejoinder, Engoron's, throughout the trial, effectively that it is uniquely capable of separating the wheat from the chaff, neither vitiates the harm now nor the inevitable harm that will result from an adverse judgment. The court's desire to, quote, get the whole picture and not, quote, blind itself does not justify admitting time-barred, hearsay, and other improper expert evidence. And that's exactly what we've been saying the judge has been doing, that he knows that none of this stuff can actually be used, but he wants to hear it, and then he'll say it's the totality of the circumstances. It's all the things considered, which is why the things he can rule on will be way harsher because it is a pattern. They say, Engoron, in sum, your bias is exemplified well by remarks made during his testimony. Specifically, Engoron, you said, this court is not here to hear what Trump has to say. Couldn't have said it better ourselves. We know. The court expounded as follows. They say, well, Mr. Case, I think you said several times we should hear what he did, what the witness has to say. No, I am not here. These people are not here, and the Attorney General is not here to hear what President Trump has to say. Of course not. No, of course not. It is a show trial. He is there to just take his abuse, be punished, be disgorged, have his whole business taken from him, and every time he tries to defend himself, gag order. Trump, my lawyers need to speak up and make a record about your unconstitutional orders here. No, they're gagged too. Don't do it, Chris! As his GF is sending him love notes, and they're adjusting the camera angles. The role of the court, says Trump's defense, particularly in a bench trial, is to carefully listen to and consider the testimony of all witnesses without bias or predilection. The foregoing statements, Your Honor, especially coupled with the court's prior and inappropriate finding that Trump is not credible, certainly creates an appearance of bias. The record facts also lead fairly to the conclusion that the court has predetermined the outcome of this proceeding and is merely going through the motions before it ultimately does what it wants and doles out its punishments. Now, on a fundamental level, the way to dispel the appearance of impropriety is not to double down on precluding comment on it or by simply ignoring the manifest existence. At this point, the taint of these proceedings is both obvious and irreversible. Worse even, the court has abrogated its constitutional responsibility to ensure that each defendant, including President Trump, receives a free trial free from even the appearance of impropriety and impartiality. Therefore, given the demonstrable partisan bias present here in your courtroom at the bench at trial from you, the only way to maintain public confidence in a truly independent and impartial judiciary and the rule of law is to bring these proceedings to an immediate halt. For the foregoing reasons, Trump's defense respectfully requests that the court grant a mistrial and grant any other such relief and further relief it may deem proper. Signed by Alina right there, submitting that November 15, 2023, Alina and Robert Clifford S. Robert, who is actually the lawyer, it sounds like, who wrote the affidavit. This also signed by Christopher Keese, who submitted the filing. Of course, a very, very nice and obvious motion that this trial is basically insane. Look at all of these donos from the judge's clerk. And so, of course, my friends, thank you for sharing this one so that everybody else can see what happened inside. The judge is trying to gag Trump and his defense, trying to gag even the lawyers from speaking out about it, but they put together a nice filing and it details exactly exactly all the improprieties there. And so we'd love it if more people saw this one for sure. So thanks for sharing it around, and we appreciate it. Now, what also happened there in trial is Alina kind of went missing a little bit, and it's not bad. Doesn't really mean much of anything. She submitted that filing, of course, so she's still on the case, but she was not there in court. And the reason being is because there are rumors that a settlement might be being devised in the case. You can see this here. Not sure what's going on, but they have said on Tuesday, various reporters on the scene have said that in New York, where the fraud trial was set to be, that it had been delayed. Well, Abba was conferring privately with Judge Engoron, and later she emerged from the meeting and left the courtroom. We've been waiting for this afternoon session to start. Judge Engoron first conferenced privately with Alina Abba, who then left the courtroom and has not returned. Nobody really knows why. And so similar observations, could be a settlement, could be something else, but very curious, they're saying. Sitting here 25 minutes late on our planned return, Abba walked out of chambers, and then the AG's attorneys went in. Recently, Trump complained about a lowball settlement offer. Could there be a settlement? We don't know. But today's trial was not too exciting. We remember that Jason Flemings was back on the stand for a direct examination. We got a couple quick updates here. Klasfeld was there reporting. He says that defense expert Jason Flemings resumed his testimony in the Trump civil fraud trial, said questioning begins again with him talking about GAAP, okay, generally accepted accounting principles. Trump's lawyer says, all right, Mr. Flemings, in the statement of Trump's financial conditions, how many GAAP departures are disclosed in the compilation report? And remember, GAAP is generally accepted accounting principles. And when Trump would create these statements of financial condition, there would be a bunch of documents in there. And there was a disclaimer that said, we did our assessment. This is what we think our condition is. And they would also make some notes that they would say, there are exceptions to the generally accepted accounting principles that we have made in this assessment. And just so you know. So, Mr. Flemings, in the statement of financial condition, how many GAAP departures from the general practices are disclosed? Now, they didn't hide anything. It's not fraudulent. They told you. We know the general principles say you do it this way. We did it this way. Here's why. He says, oh, there's quite a few. Now, they say here, Engoron rejected these defenses, but they're trying to bring it up. So Trump's lawyer, Jesus Suarez, is up. He says, were these disclosures just boilerplate? Flemings says no. They ask another question, and there's an objection. He says, sustained, but it was a good try. Morning recess, not much there, kind of quiet. Now, Flemings, his testimony then turns to the accountant's obligations to address the obvious GAAP departures. So what do you do when there is a GAAP departure? Don't you disclose it? And he says, yeah, you know, I don't even know what the testimony is. Looks kind of quiet. So Flemings, the cross-examination begins. Tish's lawyers come up. They say, Mr. Flemings, have you reviewed Trump's statements of financial conditions from 2011 through 2021? Yeah. Can you confirm that they had adequate disclosures in them? He says, well, I don't believe I did that for all of the disclosures. Like, I don't think I looked at all of them. Well, those are the years at issue in this trial. I said, well, you know, I can't really be the judge of that. He says, the standards are very permissible. All right. So if it's a gap, if you're saying there's a deviation from the GAAP principles, it's pretty permissive. So as long as you just disclose anything, I think it's probably good enough. Do you believe it's appropriate, Mr. Flemings, for a client to perform 12 calculations, choose the one that's the highest, and not disclose any of the others? Flemings replies, yeah, that's correct. It's appropriate for them to do that. Are you discrediting the testimony of another accountant, Donald Bender? And he says, no, his testimony is inconsistent with the standards applicable to the compilations. His testimony is inconsistent, so he's wrong and I'm right. And that's basically all we got out of the trial today. InnerCityPress was also stopping by over there, and he had a couple things to say. He said that they were there back in trial. Engoron returned to say that the Trump org had filed a proposed order to show cause, and would the AG's office like to respond? And I've not seen that document, so I'm not sure what that is. Here is the headline of it. It says, upon reading and filing the affirmation of Clifford Robert, upon the pleadings and therefore and having sufficient cause, it sounds like the Trump organization is complaining about what the Trump defense just lodged there. And so here is all we got. They say today was a lot more talk about GAAP. And so not much more happening in court, in trial by Trump's defense. We just had Jason Flemings there, and it sounds like it was pretty short trial day, but we did have the big motion for a mistrial. And of course, my friends, there will be a lot more to come on this. There's no doubt that Tishy and her defense or her government will respond to this. We'll see what Engoron does. This will put a nice line in the sand. They can appeal this and ask what the Court of Appeals has to say about it there in New York. Of course, we'll be here continuing to cover. I hope you join us and subscribe. Thank you for checking out robertgovea.com. You can access all the PDF documents that we went through. The mind map is there. You can get daily show reports. Sign up for the newsletter so that these segments are delivered to your inbox. Don't forget to subscribe and share this with a friend or family member so they can see what the heck is going on in these cases. And we'll look forward to seeing you on the next one.